This is my last meeting as president, so my name is Susan Good. I'm from the Central Valley, a public member, and I would like to call the Dental Hygiene Board of California's meeting to order. We're going to start the meetings with a roll call. Edsel and Pujol, would you please take the roll?
Susan Good.
Present.
Michelle Hurlbut.
Present.
Noel Kelch.
Present.
Sandra Klein.
Present.
Timothy Martinez.
Present.
Nicolette Moultrie.
Present.
Edsel Pujol, present. Gary Shea.
Present.
Evangeline Ward.
Present.
Everyone is present.
And we have a quorum and 100% participation. Thank you, everyone. Before we discuss the items on the agenda, I have a few announcements to make. Some of you may be new to the meeting today, and you weren't here yesterday, so important thing, where the restrooms are. There, you leave this room, go to the right, then go to the right again through the double glass doors, and then to the left, and then to the left again, and there they are. Real complicated, but really not. You'll easily find them. Second, this meeting is being webcast through website links, so our meeting is live on air, and it's also being digitally recorded to ensure accuracy for the meeting's written minutes. And quite a few times, this kind gentleman over here will be waving his hand or something, and that means we're not speaking loud enough or into the mic. So please take a moment to turn your cell phones to silent, vibrate, or off to eliminate the possibility of a disruption during the meeting. And in a continuous effort to be green, many of our members and staff will be viewing the meeting materials on their laptops or other electronic devices rather than a hard copy binder during the meeting. And then lastly, to comply with the Bagley-Keene Open Meetings Act, all action items of the board and subcommittee meetings and meetings consisting of 3 or more members are now required to record the vote or abstention of each member present for that action item. This means that the board and subcommittee meeting minutes must include each of the members' names under the appropriate vote category of yes, no, abstention, and other. Staff has prepared voting records for the full board and the subcommittee. That was for yesterday. And that's all of my announcements, so I welcome you, and we'll proceed with the meeting, which takes us to the first agenda item. Actually, it's the second one, and it's discussion and possible action on the Education Subcommittee report. Edsel Pujol, Chairman, please present the agenda item.
The Education Subcommittee would like to bring this recommendation to the full board. It is the proposed regulatory package 16 CCR section 1105, requirements for RDH educational program, including the acceptance of advanced placement coursework or examination by dental hygiene educational programs.
Is there a motion? It comes from the committee as a motion. Is there a second?
I'll second.
It's been moved by the committee, seconded by Noel. Let's have discussion. Any comments from members?
I have a question on the second page of this under college level general education courses in the topic areas of. I just wanted to point out to the board that in the CODA standards, it does use the wording oral and written communication. Now, with that said, I don't think that oral communication in English, as long as I guess the English includes written communication, would be objectionable, but I just want everyone to know that what the CODA standard says. And so I just don't want to see us get into a situation where we're in conflict at all. So, and then I do want to amend C on the next page where it says organic chemistry with biochemistry.
Could you wait a moment, because we all need to get to that section.
Okay.
Michelle, can you identify where you're reviewing, please?
Are we not talking about this section?
Yes.
Oh,
We're
okay.
talking about education, but which
So it's on 1105. It's under F
I'm
admission.
talking about education 3, education
Oh, three.
Thank you. Now, section.
So it's 1105, Section F, admissions for those that are on their laptops. Admission B, capital B, 1B, I guess.
And your,
So my comment was, oral and written communication is exactly how the Code of Standard writes, that courses need to be in oral and written communication. And so my slight concern is whether or not splitting it out to oral communication and English, whether that could be in any way a conflict between the Code of Standard, which says oral and written communication courses. We're assuming that English is written. I think we'd have to make sure that it includes written.
and I had that same question. It says, I was wondering why was it removed?
I'm not
So-
on that subcommittee, so I can't speak to that.
So can anyone answer that question? Why was that removed? What was the purpose?
I think in looking at the language, I'm sorry, Anthony Lum, Executive Officer. I think in breaking out the language, it was to specify, according to the advanced placement requirements, how they separate it out from math and English. So we decided to separate those so that way it's identified that those prerequisites are covering for math and English separately.
So I do believe that in Title V, which is the community college, most of the dental hygiene programs are in community college and/or students transfer from community colleges to 4 years. And the 4 years do the exact same thing. It is written in oral communications. And then within that group of courses, you do have the freshman composition, you have the speech class or the communication class, and then you also have the critical thinking class. So usually those three are packaged together under the oral and written communication as a heading. So I do believe that as long as we have the oral and written, even if we're separating those out so that you can pick out the AP English piece of it, that should meet or satisfy CODA.
I mean, we can leave the, remove the strikeout on the oral and written communication and just leave the breakout the way it is as well. Keep them both in as a suggestion.
Might it be better to leave the oral and written communication as courses in that topic, strike the oral communication in English, and leave the advanced placement exam score exemption may be accepted in lieu of these courses? I don't think there ever is an advanced placement for oral communication. Well, there could be maybe an advanced placement for speech, but I've never seen it, but you could do it that way as well. I guess my point is, as the educator on the board, I just want to make sure that we're aware that if we do oral communication in English, we must make sure that the English has written communication in it. So I'm okay as long as we're just aware.
How about adding and, after English, adding and written communication?
English with
Or
written.
including, or some other word that links the two?
It may be better, I think I like Michelle's idea of keeping the oral and written communication and then under oral and written communication, putting in the,
Or just listing English?
well,
As well.
you still need to get the oral communication.
I'm saying keep that in there,
Right. But I think, or can we just add an asterisk to the oral and written communication and say that AP English would satisfy one of those? That might be the easiest way. So as the,
I think the easiest way is to leave oral and written communication, put an asterisk, strike I and II, and down below put these courses, where advanced placement exam score exemption may be accepted in lieu of these courses.
Yes.
That would be the easiest, and just, that is a little broader And it still would allow an English course that has written communication. It could allow a written communication course. I don't know if anyone has that now, but I mean, it would be a little broader. Again, I don't know what the subcommittee was thinking, so I'm not on that subcommittee, so.
I think the subcommittee may consider that as an amendment to the motion.
I think we should leave English in there because that is a specific English AP class, and you specifically put the other AP classes. It can be oral, written, and then also English.
And I personally don't see anything wrong with leaving it just the way it is, but getting rid of the line through oral and written communication, the strike-through. It's easier, and it means the same thing, doesn't it?
Well, it infers that you have to have a course in written communication and in English. And I don't think we want to do that, personally. I think we are assuming that written communication is English, is how I'm reading this.
But is that the correct assumption?
And I would defer to the subcommittee.
I don't think we want to create any barriers for the programs or for the student.
Since Dr. Petty has had a lot of experience with this and going to the schools, can you give us some input here, Dr. Petty?
There has been some confusion regarding English and the written communication. So when I'm checking through, there are different courses that schools are accepting. I'm fine with the AP exam. However, the courses, there's no way to check to make sure those AP courses have the written communication. But, because they're taken at different high schools. So if the schools can prove that they have English, AP English along with, English with communication, with written communication, I'm fine with that, then I can check. But, it's the board's decision.
I think I'm in favor of leaving English in there, and we can have the oral communication because of the fact, like Sandy, I'm going to say Susan, Sandy just mentioned that it is a separate class from speech and English, so that way it's not something to where it's confusing.
So for clarification, are you suggesting, what kind of an amendment are you suggesting?
I think I was fine the way it is right now. But if I'm not aware, if I'm something I don't know, then please continue to discuss it. But I think it was fine the way it's written.
I think my concern is English doesn't necessarily mean it's written communication. Doesn't necessarily mean that. And so code is very specific. And my worry is now as a program, and I know there's other people that are in programs, it's a program, now I'm going to have to make sure I have an English course and a written communication course. Even though they could be one and the same. I get that as well. Actually, I'm going to move to amend by removing the strike on oral and written communication and striking out oral communication and English, and then where the asterisk is, put these courses.
Where's the asterisk?
Where it says advanced placement exam score exemption may be accepted in lieu of these courses, because oral and written communication are going to be two courses.
Okay, but then does that exclude English because it isn't listed?
It's exactly how we've always had it, and English composition is usually what is used for written communication.
Is there a second to the amendment?
I'll second it.
It's been moved and seconded to amend the subcommittee's recommendation on the item, page 2, FB, to
Remove the strike
Remove
on
the
oral and
strike
written communication, put an
and-
asterisk.
And
behind-
remove oral communication in English, and then down in the asterisk on advanced placement, the second one, say, and may be accepted in lieu of these courses. Is there discussion on the amendment?
But you're listing out math, cultural just math is the only asterisk besides English, correct?
besides oral and written communication. It does mean that somebody could, if there was ever an AP placement exam for speech, it could include that. I
so
don't
you-
think there is one now.
And so you would also be putting an asterisk on the oral and written communication?
Yes, I did.
Okay.
Which wasn't, we didn't realize that, okay.
Because I know the English AP exam does include a written part.
I think what CODA wants is they want people to have a prerequisite course in oral communication, which is usually speech, and written communication, which usually most of us do an English composition course. Which is, I think written communication means the student is writing.
I'd like to ask Dr. Petty again whether that would suffice when we're going out into the field and making, and she's having to educate the schools on it.
My only concern with keeping oral and written communication together, they might say that the AP English has the oral with it or the English with it. There's no designation. So for ease for me to audit the schools, you could have oral communication, written communication with the asterisk, which can be accepted by the AP course. But that is my opinion.
I'm okay with that.
Is the second to the amendment okay with that?
Yes.
So then the amendment would now read,
The amendment would be striking English and inserting written communication with an asterisk.
and still keeping oral and written communication at the top.
As stricken.
Stricken.
It would still be stricken. Is that a word?
Stricken? Well,
Striked?
Struck.
Struck. I know. Obviously, I didn't do well in that course.
are there any other comments on the amendment? Okay, Gary.
Not sure this was clear, but both would have asterisks, correct?
Just the written communication would have an asterisk, because honestly, I don't,
Others, no, okay.
yeah.
Well, there might be in the future.
I know, but I think at this point, we should just stick with what we know.
All right, that's fine.
Personally, but I'm open to it, but.
I'm just going to throw this out there. So the language that's in Title V, Section 55063, under the subheading, it's language and rationality, and the three are English composition. So I don't know if English composition would kind of clear up the written part of the English instead of just leaving English by itself. Do we want English composition? And then the other two are the communication and the analytical thinking. So we're not asking about the analytical thinking part, but would English composition clarify that it needs to be written, because usually English composition is the freshman English that the AP is satisfying.
I would think that it's generally good to track language from another code so they would be the same, so there's no mistake.
Any changes recommended?
Are you suggesting that we strike written communication and insert English composition? You're going to amend the amendment.
I think I'm a little lost. So,
So what the amendment that's on the table right now
Yes.
is leaving oral and written communication whatever. It's got a line through it. Struck out. Striked out. Okay.
Okay.
Oral communication's there, and instead of English, we inserted written communication with an asterisk.
Or change it to.
But I think you're suggesting strike written communication and insert English composition. No, you're saying no to do that?
That's against CODA. CODA
Says
prescribes
English.
written communication.
Okay. But I think you, okay.
Can I, as the
Any other-
SME? Yeah.
I understand that. I want to make sure there aren't any other comments from the committee on the amendment. Okay. Now, do we have any public comment on the amendment?
I'm Joanne Galliano, subject matter expert. I think that you can go either way. You can stay with Title V language. That's what most of the schools use in California. It's still written communication. So I don't think that CODA gives that label, but in the intent, they say what the intent would be a course that has written communication. So I don't think that it's different from CODA, but it's not confusing the intent. It's not changing the intent. CODA's intent is that there's a composition course, and that's what we look for when we go to the schools and look at their prerequisites. So I think that if you want to stick with Title V language and put English composition, because most of our schools, that's what they use, I don't think that that's going to be in conflict with the CODA standard, which says written communication. Probably because other states may not call it English composition. They may call it something else. Who knows?
Adina?
I agree with Joanne. However, in our regulations, we refer to CODA quite a bit. We do not refer to any of the educational code language. So that's, I'd like to keep it more towards the CODA and the CODA language as opposed to Title V. But that's, it's just a suggestion for the board.
I believe that, and please correct me if I'm wrong, but state law supersedes CODA. So Title V is our educational code in the state of California, so I think that this body should follow what's already been established with the state of California.
I do think, in all respect, if we ended up putting written communication, that would supersede anything else. I mean, if it was that, we have other things that supersede the title.
Right.
Yeah.
But I don't think that we've tried to clarify to the point that we are currently with trying to accept the AP as the English and math. So.
What about if you put written communication and composition? Just throwing it out. Okay, so we are still talking about the amendment as is with the written communication. Is there any other public comment?
Tona Steve from Delaware Valley College. I just wanted to let the board know that the AP English course we're looking at is titled AP Language and Composition.
Thank you. Any other member discussion? Then we will proceed to vote on the amendment as is. So, Etzelen, please call the roll.
Susan, could they reread what the amendment is? What's
The
current?
Do you want me to do that, Susan?
Yes,
Okay.
please.
The amendment is to strike English and insert written communication with an asterisk. And that's it.
Etzelen?
Yes. Okay, Susan Good,
No.
Michelle Hurlbut,
Yes?
Noel Kelch,
Yes.
Sandra Klein,
Yes.
Timothy Martinez,
Yes.
Nicolette Moultrie,
No.
Edselen Pahol, yes. Gary Shea,
Yes.
Evangeline Ward.
No.
The amendment passes. We now will continue discussion on the subcommittee's recommendation.
I have another amendment I would like to place. It would be under, so we just managed under B, college level general education courses in the topic of. I'm asking that you move over to C, college level biomedical science courses, of which must include a wet laboratory component in. I just want to make sure we're all in the same area. And you'll see under there that there's been some suggestions to change by adding inorganic in front of chemistry and organic chemistry with biochemistry with in front of biochemistry. I want to remind the board that standard 2AB includes courses in chemistry and biochemistry. Therefore, I would like to insert biochemistry or in front of organic chemistry with biochemistry. So it would read biochemistry or organic chemistry with biochemistry. There are programs that have a biochemistry course. So this way they would not have to change their course to an organic chemistry course with biochemistry. So my suggestion then is just to put biochemistry or, and then leave organic chemistry with biochemistry.
What about 3, inorganic chemistry?
I think inorganic chemistry will be okay. I need a second.
I'll second.
Thank you.
It's been moved to amend moved and second to amend the.
It would be C4, yeah.
Recommendation C4. Sorry, thank you. Hey, it wasn't even him, it was you this time. That's good, you saw him, good. Okay, thank you. Anyway, item 4 would read biochemistry or organic chemistry with biochemistry. Is there discussion on the amendment?
I'm in
Noel.
favor of this. I just want to double check with our expert to make sure that this is going to work and what we're doing with the schools. Okay, thank you.
I have a quick question. Is the organic 2 semesters or 1 or?
It's usually 1.
Okay.
Any other questions or discussion on the amendment by the members? Seeing none, any discussion or comment regarding from the public? Seeing none, we are then ready to vote on the amendment. Would you read it again, please?
The amendment is to add under C4 biochemistry or, and leave the remaining organic chemistry with biochemistry the same.
Excellent.
Susan Good,
Yes.
Michelle Hurlbut,
Yes.
Noel Kelch,
Yes.
Sandra Klein,
Yes.
Timothy Martinez, Nicolette Moultrie,
Yes.
Edselen Pujol, yes. Gary Shea,
Yes.
Evangeline Ward.
Yes.
The amendment passes. We now go back again to the subcommittee recommendation document. Is there any other further question, discussion, comment?
I just have a typo. Well, where it says Center for Disease Control, it should be Center for Disease Control and Prevention. That's their title.
And where is
So
that?
that is under, it would be under, let's see where we're going. I gotta go backwards here. Yeah, it's a little n, but it's under, yeah, little n.
So
C,
Center for Disease Control and
prevention.
Prevention.
I just think it's a typo, really, more than anything else. And it's still called the CDC.
And I would like to add to that it's the centers with an S.
An S, okay.
Thank you.
Thank you.
Is there any objection to including those
As a typo, maybe?
corrections? Well, if there's no objection, we should be okay, Jason, right? Okay,
Move to adopt the report as amended.
there was also already a motion on the floor but not as amended. Okay.
I'll second that.
It's been moved and seconded to approve the subcommittee report and the changes to this area as amended. Is there a discussion, comment from the members? Any discussion or comment from the public? Seeing none, we are ready to vote. Roll call, Etzlin?
Susan
Not roll
Good.
call, but, yes.
Susan Good,
Yes. Again,
Michelle Hurlbut,
Yes.
Noel Kelch,
Yes.
Timothy Martinez, Sandra Klein,
Yes.
Nicolette Moultrie,
Yes.
Edselen Pujol, yes. Gary Shea, Evangeline Ward.
the motion passes. We now move to the next item. Etzlyn?
Yes, we have another item here from the Education Subcommittee, and that is a recommendation to the full board on the proposed draft application language for approval of new registered dental hygienists in alternative practice educational programs. So we're asking for approval.
It's a motion, I take it, so.
It's been moved and seconded to approve the subcommittee's, what was it? Recommendation. Sorry about that. Any discussion? Member discussion? Any discussion or comment from members of the public? Seeing none, we're ready for the vote.
Susan Good.
Aye.
Michelle Hurlbut.
Yes?
Noel Kelch.
Yes.
Timothy Martinez.
Yes.
Sandra Klein.
Yes.
Nicolette Moultrie.
Aye.
Edselen Pujol, yes. Gary Shea.
Aye.
Evangeline Ward.
Yes.
The motion passes. We now move to, and thank you very much to the subcommittee, we move to the discussion and possible action on the legislative and regulatory subcommittee report. And we'll, Noel Kelch, Chairman, please present that item.
Well, we had a hearty, healthy discussion on the areas that we brought forward. And the first one that we discussed was Section 1902.3, RDH licensed in another state and issuance of permit to practice, the teaching position requirements. And I'm going to turn some time over to Tony. This was going to be worked on, some clarifications made before today. There was some concern from the committee on the 5-year limit, as well as fingerprinting.
So staff and legal worked on some language that resulted from the discussion from yesterday's meeting. And a draft of the proposed language was distributed to the members, and I believe there's some copies on the table for the public. So what they did was to, in the second sentence of this section, on the time limit, we added in some language that states, a special permit shall remain operative for a period of 5 years, after which time the permit shall lapse and terminate. And then further down, new language was added into, on section F, furnishing satisfactory evidence of having successfully completed, that's existing language. G is the new language. And what that is, it addressed the fingerprint issue. An applicant for a special permit shall be subject to the fingerprint submission requirements as provided by section 1916. So those were the amendments that were presented to the subcommittee for approval.
Do I hear a motion? And a second?
I second.
Okay. Do we have any discussion? Any discussion from the public? Seeing none, we'll go ahead and take a vote. Susan Good?
Aye.
Michelle Hurlbut?
Yes?
Noel Kelch, yes. Timothy Martinez?
Yes.
Sandra Klein?
Yes.
Nicolette Moultrie? Yes. Edselen Pujol?
Yes.
Gary Shea?
Aye.
And Evangeline Ward.
Yes.
That'll be moving forward. Thank you so much. The next area that we talked about was section 1913, dental hygienist authority to perform procedures or provide services. As we discussed this, no, that's the wrong one, sorry. There was a yes vote across the board on this topic. Do I hear a motion? And a second?
Second.
Okay, and any discussion? So we'll go ahead and take a vote. Yes.
Noel, we have been asked by legal to restate the motion and the item and everything.
Okay.
So if you would please do that.
Okay,
for the record.
absolutely.
Yeah.
So the motion was to move forward with the changes to 1913, dental hygienist authority to perform procedures or provide services. And the motion, do I hear a motion on the floor? Can you repeat it? Okay. And who seconded it? That's what you're asking for, right? Okay. Okay. All right. Do we have any discussion? Any discussion from the public? So we'll go ahead and we'll take a vote on this.
I just want to make, are we on
1913?
1913? We went backwards, okay. I do want to ask just a procedural question. Should we be adding at the end of each of these statutory amendments that we're approving, that we're directing staff to place them in the omnibus bill, and those that are unaccepted will be, I mean, should we be adding that on? I think we should be adding that on. What do you think?
Well, it'll be an administrative action, and, you know, items that we can submit for omnibus, we will attempt to do so. However, on the substantive changes, we'll need legislation.
I believe there was language that was included in the board materials that kind of states that effect.
It does, under the action requested, but I started.
It should, yes.
Okay. Can we just add that language at the end then? I know I didn't do that with the ones that I just did previously. I apologize for that, but I think we should, we have kind of standard jargon that we use when we direct staff to place it in the omnibus bill. I mean, I think we should be saying something more than just agreeing to make changes.
So go ahead. Then go ahead and go
I
back
don't
to
know if
that.
this language that I'm looking at is the official language that we use. So direct staff to submit statutory language changes in the annual omnibus bill sponsored by the legislature, and any substantive changes that are unaccepted for the omnibus bill proposal will be sought through sponsored legislation.
And Michelle, where did you take that from?
I took it off the cover page of the memorandum that went to the subcommittee before we actually started looking at the changes.
So are we allowed to say, quote, the omnibus bill statement made earlier?
Yeah, you could just treat it as a friendly
Okay.
amendment.
Okay. So I can go ahead and have everyone vote now?
Was there any further discussion?
Any further discussion? Any discussion from the public? All right, seeing none.
Is this still 1902.3?
We are on 1913.
1913, okay.
Seeing no further discussion, we'll go ahead and take a vote. Susan Good?
Aye.
Michelle Hurlbut?
Yes.
Noel Kelch, yes. Tim Martinez?
Yes.
Sandra Klein? Is absent. Nicolette Moultrie?
Yes.
Edselen Peugeot?
Yes.
Gary Shea? Evangeline Ward?
Yes.
Moving on to the next, which is.
Motion passes.
Motion passes, thank you. I'm moving on to the next, for 1917. This was, we had a nice hearty discussion with this, and we decided that we wanted to hear the new language, and Anthony and Adina worked on that yesterday. So if everyone can go to 1917, you were given a piece of paper, and we can take a peek at that.
So the proposed language that staff has worked on after our lengthy discussion yesterday, revised 1917 little b with changing 2 years to 3 years, and then we added in subsection H as in Harry because of the identified gap in the discussion that we had yesterday of individuals who don't qualify for licensure by credential, but yet have experience in working in another state for a certain period of time. So what we added in H was for out-of-state licensee applicants that do not qualify for licensure by credential pursuant to Business and Professions Code Section 1917.1, proof of a current license issued by another state that is not revoked, suspended, or otherwise restricted, and proof of completed clinical practice as an RDH for a minimum of 750 hours per year for at least 3 years immediately preceding the date of this application. So staff presents this draft language for the subcommittee to discuss and hopefully approve.
Do I hear a motion? Okay, a second?
Second.
Do we have any discussion on this? Yes, Michelle?
Does this not place us in conflict with language for licensure by credential?
The draft language is specific for individuals who have passed REB or credits, because indicated above, it's listed that this section is only for those individuals that have taken REB or credits. Licensure by credential is using the license that they've obtained in another state and have passed a clinical exam, but not necessarily REB or credits.
Okay.
Any other discussion from the committee? Any from the board, I'm sorry. Yes, Michelle?
I'm curious how you came up with 3 years versus adding this in for 2.
Well, the two that was voted on before is kind of what caused the issue to begin with the gap. So with staff's original recommendation of 5 years, after deliberations yesterday and discussion, that was determined to be too long for individuals to not practice and then all of a sudden apply for a license after 5 years of non-practice. 3 was kind of a compromise, and it fits the bill for those individuals that have contacted staff in regards to not qualifying for licensure credentials, but also have recently taken an exam, but not within the 2 years. So 3 is kind of a compromise.
Any other discussion? Any comments from the public? Seeing none, we'll move forward with a vote. Susan Good?
Oh, could you please restate the motion in its entirety? I'm sorry. I wasn't doing that either before, so.
Okay.
But I remembered Jason's request.
Okay. So we are moving forward on 1917, the dental hygienist requirement for licensure, and the amendments that were made, the new language that was brought forward today. Is that good enough?
And direct staff to submit the statutory language in the annual omnibus bill sponsored by the legislature.
Okay.
And if
Oh,
not,
there we go again. Okay. I'll be pointing at you over and over again. Okay. Susan Good.
Aye.
Michelle Hurlbut.
Yes.
Noel Kelch, yes. Tim Martinez.
Yes.
Sandra Klein.
Yes.
Nikki Moultrie.
Aye.
Edsel Pouget.
Yes.
Gary Shea.
Aye.
Evangeline Ward.
Aye.
Thank you. Moving on to number 1917.1, dental hygienist licensure without examination, out-of-state hygienist, which is on page 2. So do I hear a motion? Okay, and
The appropriate language that has been read through the prior one.
thank you. And do I hear a second?
Second.
Do we have any discussion? Any discussion from the public? Seeing none, we'll move forward with the vote. And this is on dental hygienist licensure without examination for out-of-state hygienists following use of the omnibus bills as stated earlier. Let's go ahead and take a vote. Susan Good.
Aye.
Michelle Hurlbut.
Yes.
Noel Kelch, yes. Timothy Martinez.
Yes.
Sandra Klein.
Yes.
Nicolette Moultrie.
Aye.
Edsel Peugeot.
Aye.
Gary Shea.
Aye.
Evangeline Ward.
Aye.
All right, moving on to voting for looking at number 1922, licensure as an RDHAP, which you will find on page 3 and 4. So as we look at this, we're going to see if we have a motion.
Move to adopt with the appropriate language that was spoken previously.
Okay, and a second?
Second.
All right, do we have any discussion? Any discussion from the public? Seeing none, we'll move forward on adopting licensure as an RDHAP using the Omnibus bill as stated earlier. So we'll go ahead and take a vote, which Susan Good?
Aye.
Michelle Hurlbut?
Yes.
Noel Kelch, yes. Timothy Martinez?
Yes.
Sandra Klein?
Yes.
Nicolette Moultrie? Edselen Pujol? Gary Shea? Evangeline Ward?
Aye.
All right, moving forward, we'll move on to 1902.3, the RDH licensed in another state, issuance of a permit to practice, teaching position requirements, looking at the omnibus bill as stated earlier. Do I hear a motion? 1902.3. Oh, I just flipped the page wrong. I gotta flip another page, so sorry. So now we are on, we did that one, okay, we are on 1930, relationship with the dentist. Correct, so we moved that to licensing, so we will not be addressing that. Moving on to 1941, approval of education programs, need for new educational programs following the Omni bill as stated earlier. We did discuss this quite a bit and went into the talking about a little bit about feasibility studies and other parts of this that we felt were important. And we all agreed on this as a committee. So now I'm going to see if we have a motion on the floor.
Move to adopt with an omnibus language.
Thank you. Do I hear a second?
I second it.
Okay. Any discussion within the board?
I had,
Yes, Michelle.
Oh, go ahead. No, you go ahead, Michelle.
Mine's more, my concern, I don't have a concern, but I noticed in statute that sometimes we say dental hygiene board in lowercase, and sometimes we say the board. And I just wonder, even in this section, sometimes we say the board, and sometimes we say dental hygiene board. And I'm just wondering if we should have staff maybe kind of comb through these kinds of changes that we're making to see whether or not we might want to just go one way or the other. And it's all over. I mean, it's not just this section. But I don't know what it seems like we should be doing the board.
Staff is continually working to revise and hopefully keep consistent within our laws, so we'll definitely take a
And
look
I think
at that.
that's definitely an omnibus kind of thing.
Correct.
Okay.
Correct.
Thank you. That was my only comment.
All right. And we also had Nicolette.
Oh, I'm sorry. I'm just looking back at my notes from yesterday, and I had a note here that the feasibility study that was discussed is different than the RDH feasibility study that we currently have, and that we were leaving out, and I might have wrote it down incorrectly, but I thought we were leaving this out until we had that feasibility study information.
We did go back and forth on that a couple of times on whether or not, but the final vote was that we were going to move it forward. We did go back and forth on that a couple of times, so.
Thank you for the clarification.
No problem. Anybody else have any comments? Any comments from the public? All right, so we will move on to the vote for this, and the vote is for, and I got to find myself again here, just a second. The approval of education programs and the need for new education. RDHAP, for new education programs for the RDHAP, and following the Omni bill as stated earlier. And we'll go ahead and have a vote. Susan Good?
Aye.
Michelle Hurlbut?
Yes.
Noel Kelch, yes. Timothy Martinez.
Yes.
Sandra Klein.
Yes.
Nicolette Moultrie.
Aye.
Etzlin Peugeot.
Aye.
Gary Shea.
Aye.
And Evangeline Ward.
Aye.
And moving forward to 1950.5, unprofessional conduct. And with this, this would also be following an omnibus bill as stated earlier. And
Move to adopt with the omnibus language.
thank you.
Second.
Okay. Do we have any discussion from the, yes. Michelle?
We're on unprofessional conduct area, right?
We're on the
I want to go
unprofessional-
back to this 24-hour, where we're striking for a period exceeding 24 hours. I just want to make sure that I'm understanding what will happen if we adopt this statutory change. So if in fact there was a needle stick, or if in fact someone swallowed a crown, or if in fact we had to send someone to get a chest x-ray, we would have to report that to us if we sent somebody to an emergency center. So I guess my question is hospital or emergency center. If you sent someone, like let's say somebody had a needle stick, and so generally for the public members, if somebody accidentally stuck themselves with a needle that we use to give a local anesthetic injection, we would send the patient and the practitioner in a school setting, we send them to a medical clinic for testing. A rapid HIV test is what normally is done. Since it says hospital or emergency center, would a medical center be considered an emergency center?
Is that acute care?
So,
Yeah, like an
so,
acute care.
Michelle, one thing I did notice here is it's saying of any patient. It's not saying the practitioner, it
I
just
know,
says
but-
any patient.
I know, but we send the source patient for a needle stick,
Yeah.
don't you?
Oh, yeah, absolutely. And I do have a question, and maybe we can ask someone from the dental board that's here. Because I think what you're saying is really important, because if we are going to get all those calls of needle sticks and things like that, this could come to a lot. This language,
Tim's behind his head.
so this language, Karen, do you mind if I ask you a question? You can ask. You might not answer it, okay. Because your language does not have the 24-hour period, do you get a lot of calls on needle sticks and on other people swallowing a crown, those kind of things?
Karen Fisher, Executive Officer of the Dental Board. They took this language out of our bill, which we're finding is a bit problematic because now any transport at all to a hospital or care center is being reported. And I think the key here is that if it exceeds 24 hours, so if you send somebody and they get taken care of and they're gone, do you want those types of things reported to you if you take this language out?
My
that
point
didn't exactly
exactly.
answer your question.
Okay.
So I mean, it's taken out for us, so we've got a lot more paperwork to do that
Okay.
I don't, we have a lot more paperwork to do, let's just put it that way.
Thank you so much.
Okay.
So my other question would be to one of our staff members, what is your experience with this?
I believe based on my experiences and the cases that I'm getting, by having the 24 hours in there, we're not capturing some of these incidences that are coming forth by other routes than the hygienist reporting them.
Okay, thank you. Any other discussion?
Based on information from our friends at the dental board, who has mentioned that exactly what I was concerned about,
Right.
that if we remove this language, we're going to get it's going to be a lot more paperwork. And I'm trying to weigh that against what Daniel's saying about feeling that if in fact we had this language out, we would be reporting more problematic issues than swallowed crowns or needle sticks. And I don't want to say that those could not be bad issues. Those could be bad issues. I'm inclined to move to remove the strike and leave at this point, and maybe leave it the way that it always has. So I move to remove the strike out and leave the language as we currently have it.
I would second that amendment, especially with, since we are limited on staff, and my concern is that we wouldn't have enough staff in the future to process the amount of paperwork that's possibly be generated.
Any other comments from the board? Any public comments? Okay, thank you.
Noel, it is somewhat disconcerting to me that we are saying that we're not going to report something that is egregious because it's too much paperwork. I think that if there is a reason for reporting it, and if it is egregious, then it should be reported, whether it's a lot of paperwork or not. And so therefore, I cannot support the amendment.
I agree with Susan. If something happens, minor or large, it should be reported. One, we can keep an eye on hygienists who make mistakes over and over and over, who might need some type of remediation. Same time, if a patient goes to the hospital and they're not there longer than 24 hours, but maybe the hospital was neglectful, and they were released and go home and still pass away. Nothing's documented. So I agree with Susan.
I feel compelled to make sure that we're all understanding exactly what this says. So if something egregious happens, most likely the patient would stay in the hospital longer than 24 hours. So that's going to be reported. And if the patient dies, that would need to be reported as well, according to this language. My point is, by removing the exceeding 24 hours, it will require every dental hygienist that sends a patient to an emergency center to get a routine test, after a needle stick, we're going to be turning that paperwork in. I don't consider that an egregious act. I mean, it's something that just happens sometimes. I don't think swallowing a crown typically is not a big deal. Usually it passes through. But I mean, it could be. That's why we do a chest x-ray, to make sure it doesn't get stuck somewhere. I think the language as written covers those egregious acts that happen. And so therefore I support not striking out the 24 hours.
I have a question about this. How often does this occur, that a dental patient winds up in a hospital or emergency center? I have never even heard, I'm sure it does, but I've never even heard of it.
It does happen.
But like, how often? Once a day, for every dentist?
In the state, more than once a day.
Right, and so it just depends, because I'm aware of an office where they extracted a tooth. The patient continued to bleed on Coumadin, no checkup, end up in a hospital, was okay later. But just the point that if the phone call would have been made, then I don't know, to me,
if they were in the hospital, they would have to report it.
My point is it like once a day, once a week, once a year?
So Gary, I think part of that is who are you serving? So in dealing with homelessness, there's not a week that goes by that you're not going to be sending someone to the hospital.
Gotcha.
So some of this is like, this means that every time I end up with someone with an abscess that has progressed to the point they need to go to the hospital, that I have to report it. And I'm not sure.
I don't think you do, because it's only if you do treatment. It's only treatment that you might do. So
except for the scheduled hospitalization, the removal to an emergency room center for medical treatment
as a result of dental hygiene treatment.
Got it. Okay, thank you.
I have a question, and this is for our education SME and others, is how would this affect our students who do needle sticks in our programs?
I would have to report it. I mean, right now, if I sent somebody to the hospital from my clinic, I would be reporting it, I would imagine. I mean, I haven't, gosh, I need to knock on wood to do that, but.
I was going to ask the question. I'm the SME for
Wait,
education.
1 second, I'm sorry, but we need to ask questions after we have the discussion here. Thank you. Any further discussion here before we go to ask the public? Okay.
I have a question for legal on this, because if you look at unprofessional conduct, it says unprofessional conduct by a person licensed under this article. A student's not licensed under this article at this point in time. Would we have to, in educational programs, well, again, they're not licensed, they're supervised, they're not licensed. So at this point, would it apply to educational institutions?
But they're supervised by licensed individuals.
Correct, but the person performing the duty is not conducted by a person licensed under this article.
That's true.
So they are not, the person who's doing the duty is not licensed by us. Again, with educational institutions, and I talked to a couple of the people that are here from educational institutions, most of the time, they have to file paperwork with HR anyways. So I think for them, it's probably easier than it is for the general public, for hygienists in private practice.
I would say under the statutory provision, no. Because it says, as you mentioned, a person licensed.
Okay, so it would not apply to students in programs.
Unless it's the faculty that got this.
Correct.
Yes.
Correct.
All right, more public comment?
Karen Fisher, Executive Officer. I just wanted to reiterate what I intended to say. If you strike this, that means if anybody you're treating faints and you send them to the hospital, you'll be required to send that information to the hygiene board to report that. So it's not the egregious cases we're talking about. This just means that if, think of the simple reasons perhaps why somebody would go high blood pressure suddenly. Well, let's send them to the hospital to get a check. They go to the hospital, they get checked, they're released. If you remove this language, you'll be reporting that to the board. That's considered a complaint, so you'll be logging in, your complaints will go up. It will then be determined by your executive officer whether or not those are investigated. So what this has done is increased our complaints and our investigations for situations that have occurred that will probably be likely opened as a complaint and closed immediately. But it still, holds that place as a complaint. You still put it on your books. It's still investigated. Now, whether or not you need that kind of information is completely up to the hygiene board. This particular section in the Dental Practice Act is primarily related to deaths and hospitalizations. And it's primarily related to anesthesia. That's what the background of ours is. So I don't know what the background of yours is. Okay, so just wanted to clarify it. It isn't more paperwork per se, but it does mean for just a simple checkout that your practitioners will be required to report that to the board.
Thank you. And our goal is to keep the consumer safe, and if we're having to report when we're doing blood pressure, when we're having to do those kind of things where we're treating someone and we discover something else, this could become very difficult, I think. Any further comment from the board? Any further comment from the public?
Tony Steve from DVC. I just want to point out the wording that says we're sending them for medical treatment. So with a needle stick, we're not sending them for treatment. You'd be sending them for an assessment. So if you want to look at the wording in that respect.
So you assess, but if there is necessary treatment, you would be having the treatment after the assessment.
Right.
Yeah.
I don't know. I guess you get into the chicken and the egg. Is a chest x-ray a treatment? Is it, I don't know. It just seems.
All right, any other comments from the board? Okay, any comments from the public?
Vicki Kimbrough, when you look at the language also, it does apply to the registered dental hygienist. Okay, if you're practicing in an office and you're not an AP, then all of this reporting ends up falling under the dentist. because it's his office. And so it'll go through the dental board. Right. So, so it also needs to apply to those who have independent practices as well. So I don't know if that requires clarification, but most accidents or issues that occur in the dental office, and the similar language is in the Dental Practice Act for dental offices to report. And I believe they have a 7-day report requirement should a death happen as a result of dental treatment. So, so there's similar language also.
Thank you. I remember before, Tony and Jason, that we said if it said dental hygiene treatment, that covered all aspects of licensure. Is that correct still?
Yeah, as far as licensure is concerned, correct.
Okay,
And that's our
thank you.
purview.
Okay.
So I think the motion before the board now is to retain the statutory language for a period exceeding 24 hours in section 1950.5. Is that correct?
Correct.
Okay.
And to put that on omnibus?
No.
No,
Not that
we're on
one.
that, not there yet. Okay.
I just want to remind members too that when we promulgate these changes in the language, we put forth as best as we can in researching outcomes that could occur from this, and so this type of discussion helps us out to understand what potential issues could arise. So with that, and seeing what could come of this with this change, staff now agrees with the change to just leave the language as is, and we'll move forward with it if that's the decision of the board.
When you say leave as is,
We're still leaving Z in.
to leave 24.
The current motion is to remove the strikeout.
Okay, so is there any further discussion? Seeing none, we'll go ahead and take a vote.
This is just on removing the strikeout.
Correct, and this is to remove the strikeout on 1950.5, and the strikeout was for a period exceeding 24 hours. Go ahead, let's see here.
By removing the strikeout, we restore the original language.
To restore the original language, yes. Thank you. Susan Good?
No.
Michelle Hurlbut?
Yes.
Noel Kelch, yes. Timothy Martinez?
Yes.
Sandra Klein?
Yes.
Nicolette Moultrie?
Aye.
Edsel Peugeot?
Aye.
Gary Shea? Evangeline Ward?
No.
Okay, the motion passed to remove the strikeout and retain the original language. Now we'll move on to look at Z, which was adding in knowing, making any statement or signing any certificate or other document directly or indirectly related to the practice of dental hygiene, which falsely represents the existence or non-existence of a state of facts. Do we have any discussion on this? Do we have any public comment on this? Seeing none, so then, Jason, at this point, I would be moving forward for a motion for this whole thing to move forward. Okay, do I have a motion
Move to adopt with the omnibus language.
and a second?
Second.
Everybody wants to, good. All right. Do we have any discussion? Any public comment? Seeing none, we'll move forward with the vote. Susan Good?
Aye.
Michelle Hurlbut?
Yes.
Noel Kelch, yes. Timothy Martinez?
Yes.
Sandra Klein?
Yes.
Nicolette Moultrie?
Aye.
Edsel Peugeot?
Aye.
Gary Shea?
Aye.
And Evangeline Ward.
Aye.
All right, now we will move on to probation options, which is 1950. And on 1950, we are on page 51, I'm sorry. Page 7. And do I have a motion for 1951?
Move
And a second? Michelle? Okay. Any discussion? Any discussion from the public? Seeing none, we'll go ahead and have a vote. Let's see here. Susan Good?
Aye.
Michelle Hurlbut?
Yes.
Noel Kelch, yes. Timothy Martinez?
Yes.
Sandra Klein?
Yes.
Nicolette Moultrie?
Aye.
Etzlin Peugeot?
Aye.
Gary Shea?
Aye.
And Evangeline Ward.
Aye.
All right, we will move on to discussion and possible action on the recommendation to the full board on proposed draft regulatory language for 1104.3, site visits, investigations, cite and fine, probationary status for the dental hygiene education programs, which starts on page 1 of agenda item 4. As second?
Second.
All right, and do we have any discussion?
We just have that correction on the Centers for Disease Control and Prevention. Just a typo under number A1. Wait, I'm sorry. A2, thank you.
Since this is a rulemaking package, I think we need to have an official.
I agree. There's a,
Have an official change of the spelling?
no, there's official language that we use at the end of when we're doing our regs that
Okay.
says about the substantive changes and directing.
Right.
You have the language, right?
I do. So
Okay.
were there any changes to the section 1104.3 yesterday? I can't recall offhand by the board.
1103.
Any of the proposed regulatory language at all?
Have we?
I don't
have we-
think so.
Have we done a reg package already and we've missed it? I missed,
No, previous we were working in statute.
okay.
So this is a reg package.
1104 did not have any changes.
The only change I'm suggesting is just making sure that the Centers for Disease Control and Prevention is correct.
Which appears to
Typo,
be
yes.
a typo, non-substantive.
So do I need to be doing something else?
I have the language there.
Okay, and Gary's going to read that for us, okay.
Okay, and to be clear, it would be approve the proposed regulatory text for section 1103.3, direct staff to submit the, I'm sorry, 1104, yeah, I'm looking right at it and reading the wrong
1104.3.
thing, oh well. All right, 1104.3, direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing.
Wow. We had a bunch of seconds. Michelle? All right, any discussion?
And there was some small typo language,
Yeah,
right?
the typo language they said was,
Okay.
yeah. And then,
I just want, this also includes the resolution for the money as well, correct? Or is that going to be a separate motion?
I think it included it.
The fees.
I believe it includes the resolution.
Yes, okay, thank you.
The entire rulemaking file, including the resolution.
Okay. So any public comment? Seeing none, we'll go forward with the vote. And Susan Good?
Aye.
Michelle Hurlbut?
Yes.
Noel Kelch, yes. Timothy Martinez?
Yes.
Sandra Klein?
Yes.
Nicolette Moultrie?
Aye.
Etzlin Peugeot?
Aye.
Gary Shea?
Aye.
And Evangeline Ward.
Aye.
Now we'll move on to agenda item number 5. And agenda item number 5 with discussion and possible action and recommendation to the full board to move current dental board regulations pertaining to dental hygiene to the board's regulatory section through section 100 request. What we did talk about was staff to work on this with the dental board. We did take a vote on it, and we were in favor of it, but there was more that needed to be vetted out by what has to happen between our staff and the dental board staff. Is that correct? Is everyone else's understanding of that from yesterday?
That's correct. Again, this is just a general authorization from the board for staff to work with the dental board on identifying sections and to initiate suggestion to move those regulatory sections that are in the dental board's regulatory sections and move it to ours. It may consist of a formal request to the dental board, but I'll work with them to see what we need to do.
Okay. Any discussion on this?
I do have a question. So if, let's say we agree that the dental board and dental hygiene board agreed on moving a particular section into the Dental Hygiene Practice Act, would it be that simple, or does it have to go through, I mean, because it's already in existence, it's just a matter of where we put it in the Practice Act?
Correct. And in discussions with the attorneys at the Office of Administrative Law, you can do a Section 100 change, which can be done for simple renumbering of regulatory sections. However, the proposal would still need to be submitted to OAL for their review. And once that's done, hopefully, because we're not changing any of the language, that it can be a simple renumbering.
What if there's sections we don't want to move, we'd rather strike when you do your evaluation? Is your plan to move them over and then we'd go through the regulatory process to strike? I mean, I just don't want us to move really old language that. Correct. Okay.
What we'll do in working with each of the programs, we understand that there's some regulatory sections that either are old or we have already in our statutes. So what we'll do is request, because you're dealing with two separate authorities, we'll request the dental board to do possibly a Section 100 to repeal that section.
All right, do we have any more comments? Anything from the public? Seeing none, we'll move forward with the vote for, let's see where I was at. Discussion and possible action and recommendations to the full board to move the current dental board regulations pertaining to dental hygiene to the board's regulatory section through a Section 100 request. Susan Good. Aye. Michelle Hurlbut.
Yes.
Noel Kelch, yes. Tim Martinez.
Yes.
Sandra Klein.
Yes.
Nicolette Moultrie.
Aye.
Edsel Peugeot.
Aye.
Gary Shea.
Aye.
Evangeline Ward.
Yes.
Moving on to number 6, discussion of possible action and recommendations to the full board to approve the board's forms and fee resolution for out-of-state dental hygiene education programs and individual applicants' review and approval of training in the procedures of soft tissue curettage, local anesthesia administration, and nitrous oxide and oxygen analgesia. Any discussion from the board? Do I hear a motion on the floor?
We really need to do a motion because it comes from a subcommittee. It's already been moved and seconded. I know
Okay.
we've been doing it the whole day today, but I'll move that we adopt these forms.
Okay.
But we don't really have to.
Okay, you're actually technically correct as far as making a motion. When it does come from a subcommittee, you don't need a motion or a second. But do we need any additional language to this?
Were there any amendments to the proposed draft application?
Not yet.
There were no amendments.
I do have a question about it, though, that
Okay.
in hindsight, it's a question for staff. Does this language parallel the changes in the language that we're making for local anesthesia? Yes. Okay, that's what I thought. I just wanted to make sure.
And I also had a question. The fee of the $500, does that cover the cost of staff processing the application? Tony?
I'm
Okay.
So we're on page number, let's see, there's no page number on it.
Just,
Where it goes and it says, the application fee for review and approval, blah, 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 is $500, and what she's asking is,
Is that enough to cover the cost of staff to process the applications?
No, I got it. Yeah, no, I got it. Honestly, I think it will be a little more expensive, but in all fairness, to charge a fee like this, it will cover and recoup most of the cost. We've never done this application before, so we had to put a number in there, and in review of the programs and what they entail, hopefully that will cover the cost. If not, we can always amend that. Or if the board determines that this is far below what we should anticipate, then I'm open to suggestion.
I do want to say that currently, hygienists that have taken an out-of-state and have to take our in-state are paying $5,000. So from going $5,000, right? Isn't that the fee to go through our local anesthesia course?
Yeah.
Yes. So with this, are we, go ahead, Adina.
Just to clarify, when a CE provider or a dental hygiene education program provides that education, when they submit their information to the dental hygiene board, they pay the same exact fee.
That's what my question was.
Yes.
So we're approving a course, not necessarily a person, yeah. So it's a school course, yeah.
It's both.
It says course in the title of the,
Right, so let me clarify. So we are approving separately. So if you refer, let me pull it. In the memo, we are requesting 3 approvals. So the first one is application for an out-of-state dental hygiene educational program for SLN. That's the first one. That is when an out-of-state, let's say Nevada, wants their dental hygiene educational program, their SLN course approved. So anyone educated at that school in Nevada can send their students over, and they've, what's the word I'm looking for? Thank you. Met our criteria. Then the second application is for the individual, let's say someone from New York. They give us their SLN information, and we compare it to the California requirements, and we determine that they are sufficient. And then the third one is the certification for, well, it's just those 2. And then the certification for competency, that's where the dental hygiene program director says, yes, this person is competent in SLN duties according to California requirements. So yes, there are 2 ways.
Just based on our fiscal state that we went over yesterday with our budget, I'm just concerned that we're kind of lowballing ourselves, and I would just ask that the committee consider raising our fees to possibly $1,000.
Just a comment now that I've caught up, and I apologize for not being in the place I should have been. In looking at this application fee, yes, it's concurrent with CE providers and the like, and the 500 should cover the cost, let me clarify, of our review of these applications.
My question would be is how are we going to monitor out-of-state programs? And if we're doing out-of-state programs like this, wouldn't there be greater expense if we're having to go? How are we going to check on them?
So anyone that is approved for an out-of-state course, they do have to submit their biennial report to us. So it's the same for CE providers here in California or someone in Nevada.
Okay.
The individual, that's a one-time shot. So we are not approving their program, we're approving them at that time.
Okay.
So someone coming in from, say, New York, they're, at that time, they were educated properly and we accept it. That's it. It's
Okay.
not saying that the program in New York is acceptable.
Okay. And then will we be looking at things like, I know a lot of states don't allow soft tissue curettage, so how would they do that? You get what I'm saying? A lot of this is, are we allowing this to be done in a dental office, or are we saying this is done at a school? How are we keeping up with?
This is done at the school.
Okay.
It's schools only. And
Is it in here that it says schools only?
Yes.
Okay. thank
So
you.
as it's written in dental hygiene educational program.
Okay, thank you.
One additional comment, because we do have the 3 requirements in our SLN requirement, and I know there's multiple states that do local and nitrous. If they don't have that soft tissue curettage to be certified under, then they will have to take the California course.
Okay, thank you. Do we have any more comments from the committee?
Yeah, mine's more on the lines of a point of order. I want to go back to the thing about moving and seconding, because, that's under Robert's Rules of Order, which is like
Okay.
the lowest form of law
Right,
that there is.
right.
Constitution of the United States being
Right.
at the top, and anything else in between modifies Roberts. So if there is a rule or a reg or a law that says that we have to have a motion and a second, then we need to do that.
Okay.
And but if there isn't, then staff can just record it as being subcommittee report. Yeah. But, so what's the answer?
I just did what I was directed,
Yeah.
so.
Can we do it?
I think at this point, we should just keep doing what we're doing. This
We're
makes
almost
sense,
done.
right? Yeah.
Yeah, okay, thank you. All right, any comments from the public?
Vicki Kimbrough, I'm also a CE provider for the Anesthesia or the SLN courses for out-of-state hygienists. My question is along the line of Noel Kelsch's. This does apply to dental hygiene programs out of state who do not have a provider number from the dental board, so they wouldn't really be submitting a biennial report because it's a program. I don't believe California programs provide a report on what they're doing. The other issue is this now does put those particular courses in out-of-state programs under the purview of the Dental Hygiene Board here. So a monitoring mechanism would have to be in place because the courses that are offered here in California can be site visited. So are we going to site visit the programs that get approved out of state? Well, not we, but the board. So there's that. And along with certification, how are they reporting the tracking of their injections as they're stated here? Is there going to be some kind of tracking report that has to be submitted for those who are being certified that have done this course through their out-of-state program? That they've done all those particular injections. For example, Hawaii, when you apply for a Hawaii hygiene license, there is a form that Hawaii requires that says that you are listing how many particular injections you have in particular categories, and you're getting certification that you have done 10 PSA injections, 10 IA injections, 5 MSA, etc. So the person who's applying for the Hawaii license is under penalty of perjury that they have done 50 injections required for the Hawaii license application. So I'm not opposed to any of this. I just think there will be required more monitoring if they are out of state.
The purpose of this proposal was because in our regulations, we do have the provision to review and accept out-of-state SLN training and education. I'm sorry, I said that word training, didn't I? However, this is going to be taken on a case-by-case basis. I have no foresight in overseeing out-of-state programs at all. Each individual applicant is going to submit their particular qualifications for us to review to see if they meet California standards. And if they do, then we will move in the direction of providing a license. However, if it comes up short and our SMEs determine that qualifications are not there, then that disqualifies them from the license. So as far as, expanding oversight on out-of-state programs and all that, that has not even come into play.
Well, and that's the question, because there would have to be some kind of oversight to make sure that they are, complying, even though they apply and they report that they're doing it. Even as a CE provider, I've already been site visited to make sure that my course actually provided what it needed to do on every time we were on campus doing it. That's my question.
But our official purview is only within California, so anything out of state, we wouldn't have any jurisdiction over.
But you're approving the courses.
The coursework that the applicant is supplying to us to see if it meets California standards.
Well, you're approving a course that's at a program. So you're saying the program course meets our standards.
I think the confusion comes, and it was my understanding, and we should have looked at this better yesterday, so we didn't have this whole issue, but I thought that initially what we were thinking that we were going to do is not approve programs, but approve individuals. So basically, we would only need the second application, which is the student one, that goes in detail, lists what the program, the course they took had to contain. They signed under perjury that they've completed the number of rejections. So we're approving the student who took the course, and the students has to provide the course in order for their application to be accepted. So we're not approving so if the course changes, we don't care because that's not what they're sending to us. I think the confusion came now. We had two applications. One that's going to approve the program, which I don't think we want to do. I think what we want to do is we simply want to have that second application, which says the student is responsible for submitting evidence that they have completed a course at an institution that covers all of these things, and all the SLN requirements are in the actual application. So we don't have to we're not approving the program, we're approving the student, the licentiate.
That does make more sense, because otherwise you would have to monitor another state's program's curriculum.
Then I do have a question then on the form that was provided in our packet. I believe it's the third form, which was the certification of competency in administration of local anesthesia, nitrous oxide, analgesia, and performance of periodontal soft tissue curettage. Within that application, it does have the dental hygiene educational program, and then the date and the attendance, but it doesn't have any verification, like going back to what you had said about like Hawaii, that have you done all of these types of injections?
Correct. They do list them out, and they have specific numbers attached to specific injections.
Right.
Not all of them, but specific
Just
ones.
so they know what
Correct.
specific criteria that we have, and they're actually signing off on that form.
Right.
I would, again, the student's application is going to have to indicate that. So the hygiene, I would hope that the program director that is signing this in the college that is acknowledging it is going to not sign it if they don't meet the criteria that the student says has to be met prior to. So, and if they do, if the program certifies it and we find that the program doesn't actually teach what's being taught, then the student is under perjury. I mean, they perjured themselves. They've provided us with false information.
I do have a question. Where's the language, Tony, in our Practice Act that allows us to approve an out-of-state? Is it, I know I should remember, because it's regs, okay, 1105.
Yeah, it's regs.
Do we have any further discussion from the board? Any further discussion from the public?
I just have a question.
that's the wrong section.
Okay, go ahead.
I just want to make sure I understand. So the application for the out-of-state, that's just pretty much saying that they're applying to provide a course and for California to accept it. Is that what they're pretty much asking?
Correct.
And then the actual student who applies, they're saying, okay, I want to come to California, here's my coursework, the school has stamped it, and they're supplying that information.
Correct.
So, okay, so the hiccup right now is can we watch over another school out of state? That's the concern.
That's where I have a concern.
I would recommend that we send this back to staff to work on and then bring it back to a future meeting so that some of this language can be worked out and the application can be reviewed in light of some of the information that we found out today.
Okay.
The reason why I'm asking Tony is I believe the language only allows course approval. If my memory is, can you tell me where the language is?
It is in 1105.2, and at the last meeting, the board approved, no, excuse me. The board approved the changes. So if you want to take a break, I could get that information for you, and, or you can move on and I'll get the information to bring it back to you.
Staff has asked that we take a break. So why don't we, it's already, 10:40 anyway, so let's take a bio break and we'll return at 15 minutes, so 5 to 11. Thank you. And I believe that our executive officer has a recommendation as well, or a request.
And I was waiting to have my turn after Nikki, and then we can go back to Tony if that's okay. My recommendation, along with what Nicolette was saying, was in looking at how other states have done this, especially New York and Hawaii, I think it would be good for us as we're looking at the bringing out-of-state hygienists in, is to have a form that gives the injections that are required and turn that responsibility over to them rather than our staff having to manage this. I also think that we should not be in the field of licensing other or certifying other out-of-state entities, because that might involve our staff having to leave the state to go and check these places out, not to mention the fact that we have a liability that goes along with that. So I would like to direct staff to go back and look at how it's done by other states for the same process, and to, at this point, see if we need to change legislatively what we had done last January, which was to give the verbiage on how we were going to go about licensing out of state.
And because of the recent discussion on this issue and the complexity that has arisen, staff would like to request the approval from the board to table this item for a future meeting.
And Jason, do we need to take a vote on that?
Well, there needs to be a motion.
Okay.
Second.
All right, we'll go ahead and take a vote. Susan Good? Aye. Michelle Hurlbut?
Yes.
Noel Kelch, yes. Sandra Klein?
Yes.
Timothy Martinez? Absent. Nicolette Moultrie?
Aye.
Edselyn Peugeot?
Aye.
Gary Shea? Aye. Evangeline Ward?
Yes.
Now, we will move to, do we have any, we're moving to item number 7, public comments for items not on the agenda. Do we have any public items for, public comment for items not on the agenda? Seeing none, we'll go to agenda item number 8, and we would like to direct the staff, the committee wanted to direct the staff to looking into how informed consent impacts both the RDHAP and the RDH, and to come back at the next board meeting and let us know if that's something that we need to address, or if it's something that's taken care of by both state and federal laws. And I'm going to adjourn my time at 11:01 and turn the time back over to you.
Thank you very much to the Legislative and Regulatory Committee, and also members of the board and members of the public. We survived. And that was very thorough, and we had a good discussion on that. That leads us to number 4, which is discussion and possible action on the licensing and examination subcommittee report. And I'll ask Sandy Klein, the chairman of that subcommittee, to present the item.
The Licensing and Examination Subcommittee had 2 items that we discussed. One was passed, and that was recommendation to the full board to revise Business and Professions Code Section 1930 to require RDHAPs to provide documentation of an existing relationship with a dentist at each license renewal. And that was added again. We went through that package in Ledge Reg, and they deferred to us. 1930, we just added the language. And shall continue to report a current relationship with a licensed dentist at every license renewal, including the dentist's name and license number. A registered dental hygienist in alternative practice shall report any termination of the existing dentist relationship and identify the new dentist with whom the new relationship has been established for referral, consultation, and emergency services within 10 days. And that's on page 4 of the Ledge Reg package. The second item that we discussed, we tabled, and that was the recommendation to determine the length of time for licensees to remain on an inactive status before remediation is required to reactivate the dental hygiene license. After discussion, we wanted to get some statistics from other states on what would be a reasonable length of time before remediation to reactivate a license. Is there a motion to accept the subcommittee's report?
I motion to accept the subcommittee's report.
Second.
Any member discussion?
I just want to make sure that the one recommendation that you're making on 1930 includes that language that we've agreed that we're directing staff to move it into the Omnibus bill, right? That kind of standard, if you're okay with that as a subcommittee.
Yeah, that's good. 1930, that we recommend this language that is in here be included in the Omnibus. You want to repeat that, Jason, or everybody just?
I have it here, that we direct staff to submit the proposed changes to statutory language in the annual Omnibus bill sponsored by the legislature, and any substantive changes that are unaccepted for the Omnibus bill proposal will be sought through sponsored legislation.
Thank you.
What is the specific legislation or regulation? This one was recommendation determining the length of time for licensees to remain on an inactive status.
That's the second one that
Okay,
we
and then-
deferred, that we tabled.
Okay, and then the first one is?
The first one-
1930.
The first one is just requiring the RDHAPs to, at renewal, to name the dentist. Because right now it's just when they get their license, and it could be years that they don't have a relationship with the dentist.
What I was just asking for was that we, in the motion, include the the actual wording that was, here, and I think you stated that, Sandy.
I read it out loud, so you can look at it video.
Okay.
Any public comment? So roll call vote. Susan Good,
Aye.
Michelle Hurlbut,
Yes.
Noel Kelch,
Yes.
Timothy Martinez,
Yes.
Sandra Klein, yes. Nicolette Moultrie,
Aye.
Edsel Pujol, Gary Shea,
Aye.
Evangeline Ward.
Aye.
Okay, passed. And that's my nice quick report.
Thank you. We will now move on to item number 5, which is the election of 2020 Dental Hygiene Board of California officers. And we have 3 positions that open each year, and they include president, vice president, and secretary. So I will now entertain a motion of nominations, open nominations for the office of president.
I would like to nominate Dr. Timothy Martinez for president.
Second.
It's been moved and seconded to nominate Dr. Timothy Martinez as president. Are there any other nominations? Hearing none, we will move on to the office of vice president. Yes.
I would like to nominate Nikki Moultrie for the office of vice president.
Second.
It's been moved and seconded to nominate Nikki Moultrie for vice president. Are there any other nominations? Hearing none, we'll move to the office of secretary. Are there any nominations?
I would like to nominate Susan Good as secretary.
Second.
That was quick.
I have had the opportunity to be secretary, but I think everybody else has too, except Gary.
Gary, I nominate Gary to be secretary.
No. I have respectfully declined, knowing that you haven't had the experience.
I second that nomination.
Okay.
Gary Shea has been nominated for secretary. Are there any other nominations? So we will then close nominations. We have a nomination of Dr. Timothy Martinez for president, Nikki Moultrie for vice president, and Gary Shea for secretary. Is there any objection to naming or electing by acclamation Timothy Martinez, Nikki Moultrie, Gary Shea? Seeing no objection, congratulations to you all. And I do want to thank Nikki for serving as vice president this past year with me. She has been very, very helpful. And also, Edsel Pujol has done an awesome job as secretary, going through all of those roll calls and all of those roll call votes. So thank you very much to both of you. Enjoyed working with you. And enjoyed working with the rest of you. Thank you for placing your confidence in me. It's been quite an interesting experience. And I was asked to write a column for the Dental Hygiene Board newsletter, and I have done that, and it'll be interesting. You're going to be able to read about what it's like to be a public member on the Dental Hygiene Board and what I've learned. So anyway, thank you. Does Dr. Martinez now take over?
No.
No, not yet. Okay.
Hold on to yours.
Here,
When does the term begin?
January 1st.
Okay, let's move on to item 6. It's the update on 2019-20 legislation and pending regulatory packages. It is informational only, and I will ask our executive officer, Anthony Lum, to present that agenda item.
Okay, so my voice is different from Tony's, so I'm Adina Petty. AB 5, so the previous reported legislative bills of interest to the Dental Hygiene Board. AB 5, worker status as far as independent contractors, that was signed into the governor and chaptered by the Secretary of State. The DHBC position was to watch it. AB 62, it's a 2-year bill regarding fiscal transparency. DHBC wanted to watch it. It's a 2-year bill and dead for 2019, so there's no movement on that one. AB 71, employment standards about independent contractors and employees. This again was a 2-year bill. DHBC wanted to watch it. AB 193, professions and vocation. This was asked to watch by the DHBC, and it's a 2-year bill and dead for 2019. AB 312, State Government Administrative Regulations Review, 2-year bill and dead for 2019. DHBC asked to watch it, and we will still watch it. AB 316, Medi-Cal benefits, beneficiaries with special dental care needs. This is a 2-year bill and dead for 2019. The board had written a letter of support as of 4/12/19. So when there's any update, we will report to the board. AB 476, Department of Consumer Affairs Task Force. The governor vetoed the bill. DHBC was just watching it. AB 496, it was signed by the governor regarding business and professions. The DHBC requested a letter to support as written as of 4/12/19, and like I said, it was signed by the governor. AB 544, professions and vocations about inactive license fees. It's a 2-year bill and dead for 2019. It was opposed as written. The board took a position of oppose as written as of 4/12/19, and again, we will stay on top of that one. AB 613, regarding regulatory fees, DHBC wanted us to watch it. As of right now, it's dead for 2019, and it is a 2-year bill. AB 744, healthcare coverage telehealth, DHBC wanted us to watch. The board wanted us to watch this. It was signed by the governor and chaptered by the Secretary of State. AB 768, business and professions and vocations. DHBC wanted to watch it. Again, this is a 2-year bill and dead for 2019. AB 931, state and local boards, commissions, and representation. DHBC wanted to watch it. It was signed by the governor and chaptered. AB 954, DHBC wanted to watch. It was signed by the governor and chaptered. AB 1076, DHBC wanted to watch it. Again, this was signed and chaptered by the government. This is criminal records automatic relief. AB 1271, licensing examination reports. DHBC wanted to watch it. It's a 2-year bill and dead for 2019. AB 1519, DHBC was in support of this bill, and this bill was signed and chaptered by the governor, or signed by the governor and chaptered. AB 1529, cannabis vaporizing cartridges. DHBC wanted to watch it, and it was signed by the governor. It was, yes. AB 1622, DHBC wanted us to watch it. It was signed by the governor and chaptered by the Secretary of State. SB 53, DHBC wanted to watch. This is regarding the open meetings, and it's a 2-year bill and dead for 2019. SB 66, federally qualified health centers and rural health clinic services. The DHBC wanted to support as written. Currently, it's active, and as of 9/11, it's in the Assembly for appropriations. However, it was ordered to the inactive file, so right now it's kind of in limbo. SB 144, criminal fees. DHBC wanted to watch, and again, this one is still an active bill, and on 7/9, it was set for the second hearing, but it was canceled at the request of the author. So we will continue to monitor all the bills that you requested watched. Oh, goodness, I'm sorry. Okay, that's why it threw me off. Thank you for catching that. SB 154, this one was vetoed, however, it was reactivated in the Senate. This is regarding Medicare restorative dental services. The board had a letter of support with concerns as written as of 4/12/19. So that one was reactivated in the Senate, so it's being changed around a bit. And again, we'll watch and see what's happening right now. SB 601, state agencies licenses fee waiver, that was asked to be watched by the board, and it was signed by the governor and chaptered. SB 653, support with concerns is written as of 4/12/19. It's a 2-year bill, dead for 2019. Again, this was regarding dental hygienists, RDHAP, scope of practice. So we will be continuing to watch. SB 786, healing arts. This was regarding the dental board. Dental hygiene board being referred to, or changing hygiene board to be written as dental hygiene board. It was signed by the governor and chaptered by the Secretary of State. We obviously supported it, and it was good. And all this information was current as of October 21st due to printing and inclusion within the board minutes or board packet.
Thank you. I wanted to comment that at our last meeting, we were talking about bills that had become, that were dead, and they'd become 2-year bills, et cetera. And so therefore, we shouldn't worry about them. We shouldn't write any letters of support for them or anything because they're gone. And I just want to cite that while this was a particular watch bill, here's an example of what I was talking about, and that's AB 1529. It was originally a telephone medical advice service, and then it was gutted and amended to become this cannabis vaporizing cartridges. And that's why that it behooves us as a committee, as a board, to write letters of support or non-support, and specifically why, for bills, because they can change, and that allows us to have our position on file, that we were not talking about cannabis, if it indeed changed. So I just wanted to point out that I finally have an example of what I was trying to say. Thank you.
One of the questions that I had about the bills that have passed is, what are their impacts on this board?
And there certainly were a number of them, so I think that's a good question.
So, for example, AB 5 regarding independent contractors. If you recall at the last meeting, it changes the definitions of employees and independent contractors, as dental RDHAPs are sometimes considered independent contractors, the DCA sent out a memo stating that this one would be one that we need to keep an eye on because it might change some of our regulations and our legislation. So regarding independent contractors and defining that. Let's see the other one. Let me find it. So,
Adina, there were a number of exemptions. So in our profession, there were no exemptions?
not to my knowledge.
Thank you.
The omnibus, AB 496 was our omnibus bill, that, hang on, my eyes are getting old. It allowed boards, provides board members appointing authority that the appointing member has the power to remove someone from the board, so that does affect us. Let's see, this one. Telehealth, that one was signed by the governor, and so it would require healthcare services to.
Could you give the number, please?
Sure, I apologize. AB 744, telehealth. It would require a contract to be issued or amended between the healthcare service provider and a subscriber. So that would affect RDHAPs, dentists. Let's see. AB 931, state and local boards, commissions, representations. This one was signed by the governor as well, and that was allowing for gender identity to have appointments to the board. So if it restructured the bill to prevent boards from being comprised exclusively of the same gender identity. So it ensured equity. AB 954, dental services, third-party network access. The bill would specify that a provider is not bound or required to perform dental treatment under the network contract because of a violation of any provisions. So again, that does affect healthcare services and how our RDH, specifically how our RDHAPs are working with their practice. Criminal records, automatic relief, this does affect us. It was signed by the governor. That was AB 1076. It requires the DOJ to grant relief to an eligible person and review their convictions and possibly not have to report some of those convictions to licensing boards. AB 1519, Healing Arts. This was the Dental Board of California's sunset bill. We supported it, and they got it, so that was a good thing. AB 1529, that was a gut and amended to address cannabis, and so that one, originally we watched it because of telephone medical advice service, but now it's cannabis, so that one does not affect us. AB 1622, it was regarding informed consent that must be obtained by a parent or guardian prior to administering general anesthesia or sedation to a minor. So, and consult with the child's dentist, pediatrician, or physician as needed. So again, that affects the way a dental practice and dental services and dental hygiene services are rendered if the hygienist will be working on a patient that is under anesthesia. Let's see. And that, okay. SB 601, state agencies, licenses fee waived. Any business that issues a license or any agency that issues a license will be asked to waive a fee if they're displaced during due to a declared emergency. So again, we have some licensees that may be in areas that have had emergency declarations. Let's see, SB 786, Healing Arts. This again replaced all our references with Hygiene Board, with Dental Hygiene Board, so that is why it is important to us. Any questions?
And this last bill was the Senate's omnibus bill, because each side does a separate omnibus bill.
Yeah, I just wanted to make a comment on SB 66, which is great, because I work at an FQHC, and the fact that you can go see a medical doctor and then go into the dental, have a dental visit the same day, definitely would, it's a good thing for us. So if there's an issue, as we integrate more and as we become more interprofessional, this is great. So I just wanted to make a comment that that's great that they're allowing 2 visits on the same day. So great.
And that was one that we did a support letter on, so yes, that was good news.
That's very good.
And I wanted to comment on AB 931, the state and local boards and the representation. It's not going to be implemented until January 1st, 2030, so it's a long ways away, but it says, when it was amended in the Senate, it prevents boards and commissions from being comprised exclusively or largely of the same gender identity, and we have 9 members, 2 are men, 7 are women, so we will or would be affected by that in 2030.
Will everybody be here by then?
I hope. I mean,
I think we're all hoping.
I'm in on this board, I'm sorry. I should clarify that, yes.
Any other questions or comments by members of the committee? Seeing none, any comments or questions from members of the public?
Since we're on the legislative subject, just a couple of dates that I wanted to make the board aware of. One is that the legislative session convenes again as of January 6th. And also, I received a call from the Senate who oversees the omnibus bill, and all proposals will be due by mid-January.
Seeing no further comments wanting to be made, this was a report, an update for information only, so we will proceed to item number 7, which is discussion and possible action on proposal for 2020 legislative omnibus bill, and ask our executive officer, Anthony Lum, to present the item.
I know in our legislative subcommittee, we have a lot of statutory changes that could potentially be presented as omnibus. However, I did want to give the full board an opportunity as well to have an opportunity to say what they would like to recommend as far as omnibus. Specifically, omnibus is created for mostly non-substantive changes, so any suggestions that you would like to present in omnibus, this is the opportunity.
Oh my goodness, you are correct.
6, what was 6, obviously. Yeah.
Number 6.
Well, can we finish this one first, since we already?
Oh, we just did that.
We did the legislation.
So what we're going to do then, and I'm going to make sure that this is okay with legal, but we went to 7, we will then return to 6 after we discuss 7. Is that possible?
Yeah, that's fine.
Thank you. So continue, Mr. Lum.
I just request any additional proposals other than what we've identified in the proposed omnibus changes language.
I do have a question for legal.
Michelle.
Thank you. In our statute, I believe we say that probationary license is for 3 years.
That's correct.
Can we change statute to have it be a range from 3 to 5 years? Or is it just understood that all probationary licenses in this state is 3 years?
No, I think it can be modified. Let me pull up the statutory section you're referring to.
I'm trying to find it as well. I'm sorry, I wasn't organized.
I believe it's 1932.
And Michelle, what is your reason for
Well,
wanting that?
my reason is oftentimes when we're deliberating on disciplinary actions that come before the board, oftentimes there's a desire to maybe have a probationary license be a little bit longer, or the probationary period, maybe that's what I'm talking about. Or probationary license to be a little bit longer. And I just wanted to give us if we could.
I would recommend that you kind of specify specific,
Okay,
if you want it 4 years, if you want it 5 years, rather than say like a range, like 3 to 5. I don't think that
We're
would be
not allowed to do a range?
I don't think that would be approved, no.
Could you do up to 5 years?
Sorry?
Could you do up to 5 years?
Yes.
So,
So we'd amend, so currently, the statutory language of subdivision B of section 1932 reads in part, the term of a probationary license is 3 years. So you want to revise that to say the term of a license is up to 5 years. Is there any?
I can't really speak why, but this board knows why. Okay, thank you.
Well, and so I will comment on that. 5 years, while we may think that that is what would be appropriate, is a long time in a person's career. And it might provide or end up with a great hardship, and people will leave the profession as opposed to correcting whatever the deficiencies were and moving forward. I have some concern about moving it up to 5.
And I will just add that the second part of subdivision B does provide for the licensee to petition the board for modification of the probationary term, including the board granting a license that is not probationary, excuse me.
On the other hand, I look at this as the ability to being able to, on some cases that we would have to deny the license, being able to take a longer period of time if that's necessary. And I like where this is going with some of the challenges that we've had in making decisions.
I like the idea, in case we have someone that might not warrant even 3 years, up to 5, maybe we can only do 1 year probation.
I would just like to have a little bit more flexibility when we do deliberate on some cases. And for me, it gives the board an opportunity to maybe elect to do a longer probationary period in certain cases versus revocation or denial of license.
So could we have a motion?
Is that what you're asking for, Tony? Our motions now? I thought you just wanted to know if we had any other
Well,
ideas.
the request was to see if you had any other suggestions for Omnibus. One comment that I wanted to
I
make.
don't know if that's going to be omnibus.
Correct.
I don't think.
And
it should be
that's what I wanted to
okay.
comment on, is that this agenda item is for items that are non-substantive or grammatical errors or corrections and the like. Changing 1932 is substantive, and it's something that, should be discussed separately, in my opinion.
So if discussed separately, are we saying that it was not on the agenda today, it's going to need to be placed on a future agenda item?
That is correct.
Okay. And those don't require approval, so, by the board. Okay. Noel, so we will note that, make sure when we get to future agenda items, we mention it again. Michelle? Noel, did you have something to add? Oh, thank you. Okay, any other suggestions for the omnibus bill? Any members of the public, suggestions for Omnibus Bill? Seeing none? We need a motion then to approve what we do have that's in here, that's been submitted in the packet. And this is,
I thought they already did that.
you didn't, what they're deliberating right now is whether we already did that or not, for members of the public.
So I make a motion to approve the changes that have been presented to us so far in this omnibus bill.
Is there a second?
I'll second.
It's been moved by Nikki Moultrie, seconded by Etzlin Pujol, to approve the recommendations that were presented in item 6 of our 7 of our agenda today. Any further discussion? Any public discussion? Seeing none, we will proceed to the vote. Etzlin, please call the roll call vote.
Susan Good,
Aye.
Michelle Hurlbut,
Yes.
Noel Kelch. Yes. Timothy Martinez.
Yes.
Sandra Klein.
Yes.
Nicolette Moultrie.
Aye.
Edsel Pujol, aye. Gary Shea.
Aye.
Evangeline Ward.
Aye.
Motion passes. We will now go back to number 6, the update on 2019-20 legislation and pending regulatory packages. Again, this is informational only. And ask the executive officer to present this item.
I will defer to Dr. Petty to update us on this agenda item.
So staff wanted to be able to give the board an update on the status of the regulatory packages that you have requested to be placed in for changes. As you can see, we have 5 packages currently undergoing review, the formal DCA review submission process, and currently 1 AB 2138 is at the agency, as well as goodness, my eyes, sorry. The 1107, the updates to local anesthesia, which included the changes, if you recall, the right and left side and the different types of injections. That one is at DCA Legal and Budget Office. The radiographic decision-making and ITR, that is already at DCA Legal and Budget Office. Retired license, that's at the Budget Office under review. And mobile dental hygiene clinics, that one just went in. I don't have a current update, but that is under, it's at DCA Legal. So those 5 packages are currently undergoing process. The inspections, investigations, that will start as soon as this meeting is over. And then 1105.2 was tabled, so that one will be in process. So the next one that will be going to review for submission is 1104.3.
Any questions or comments for Dr. Petty on this item, on what was just presented?
I do have a question. Is there a length of time? Is there anywhere in law that says how long these individual entities can have to look at the regulatory packages?
Unofficially, they're using like 30 days to review is what I've been told. However, obviously depending on workload, but there's not a time frame for our pre-reviews that these indicate, and an official time clock doesn't occur until we actually file with the Office of Administrative Law for the 1 year to implement a regulation.
So the 1 year time period is triggered once it's submitted to OAL. Once it's gone through the entire rulemaking process, all the documents have been compiled, they'll typically have 30 days to review it. And by them, I mean OAL. As far as agency review, and through the various layers of DCA review, there's not a specific time period for them to kind of say, get this done by 30 to 45 days. It fluctuates with agency and within legal, within budgets, so.
I guess my concern is, the first one was rushed. It was supposed to be a rush, one that had high priority.
My understanding is that agency just approved that for publication this week, or last week.
It took 7 months. Okay.
It's not the only, AB 2138 is for all DCA boards and bureaus, so you have 40-plus rulemaking files all in the same thing that are being reviewed, all being sent to agency, so, admittedly, it's a lengthy process.
And the department is working because they have a specific legal unit now that will address regulations. I believe Jason has told me that they're fully staffed. Also, the budget office has designated a staff member to review the monetary aspect of our regulations. So hopefully that'll help streamline the process as well, at least through DCA.
Any other questions or comments on this item? Seeing none, any comment, question from members of the public? Seeing none, once again, this is for information only. So we will proceed. Thank you for that report. We will proceed to number 8, which is the update on the status of dental hygiene educational programs. And Dr. Petty, please present that item.
So the first two updates, Sacramento City College was visited on December 7th, 2018. They were given until an original deadline date of February 28, 2019 to correct any outstanding deficiencies. They did have to request an extension due to internal issues, and the executive officer granted that. All their outstanding deficiencies are corrected and they are now in compliance, and I provided you with the SEC report. Diablo Valley College, there was a site visit on February 26, 2019. Deficiencies were required to be corrected by June 1st, 2019. There was, again, some minor timing issues, and they requested an extension, and they were given to a timeline of December 1st, 2019 to correct those deficiencies. I've been informed that they're working on it. It might be a week delayed, but they're working on the progress, so that's what matters. And so it's a minor deficiency just with hiring, and they should be in compliance on time, or just a slight delay. Cabrillo College, we reviewed. We went for a site visit on November 7th, 2019. The site visit report is in progress because it was just 2 weeks ago, so we're waiting for review. And that site visit report will be provided for you at the next board meeting. San Joaquin Valley College, again, was visited last week on November 14th. The site visit report is in progress, and that full report will be provided to the board on at the April meeting.
I have a question for you, and that is, so we had, out of the two, we had delays. Is that quite often done, and then do we extend them in all circumstances? Depending on the, how is that decision made?
Okay, so if it's not an egregious matter, if it was something for infection control, no, we do not extend. If it's something that would affect the public, there, again, all my reports are vetted through, I was going to say Professor Lum. Mr. Lum, everything's vetted through him. And if there's anything, they'll call and request because something has to go through HR or, or hiring processes. Those do take time. And, as long as it doesn't affect the care that's given to the patients, to the public, or, and they have staff coverage that will take care of those things until the permanent person is hired, then, again, Mr. Lum makes that decision.
Are there any other questions or comments?
I'd like to make a comment. I'd really, having gone through the process this month, I'd really like to thank this board for the staff and for the professionalism that was conducted when they came to the school, and what a great learning experience it was for me, for them to come in and do their job, and it was handled so professionally. I was not treated like a board member. I was treated like everyone else, and I want to thank them for that.
Well, that's good to know.
Was it a scheduled visit?
It was a scheduled visit.
As of now, we have had no unscheduled, yeah.
Any questions or comments from members of the public? Seeing none, we will then, this again was a informational only, so we will proceed to, and thank you, Dr. Petty, we'll proceed to the item number 9, which is the report on licensing statistics. And Tracy Napper, would you please present that item?
Tracy Napper, Program Analyst. For information that I provide is the licensure statistics for the Dental Hygiene Board. You will notice that the active licenses that we currently have are 18,049 for RDHs. RDHAPs, we have 594 active licenses, and for the RDHEFs, we have 24. And the fictitious name permits, we have 123 that are active, totaling 18,790 licenses that are active. Our inactive status, we have 1,900 RDHs, 48 RDHAPs, 2 RDHEFs, and 0 fictitious name permits, totaling 1,950. The delinquent status licenses we have for RDHs is 3485 and 97 for the RDHAPs, 4 for the RDHEFs, and 76 for the fictitious name permit, totaling 3,662. The subtotals for, which was submitted in your package, you may not have it, is 23,434 for the RDH, 739 for the RDHAPs, 30 for the RDHEFs, and 199 for the fictitious name permits, totaling 24,402 for our license statuses that are active, inactive, and delinquent. The other license statuses are considered non-licensed subject license, and that totals 8,994 for the RDH, and then 26 for the RDHAP, and 2 for your RDHEF, and 45 for your fictitious name permit, totaling 9,069. So our total RDH population is 32,428. RDHAP is 765. RDHEF is 32. And fictitious name permit should be 244. And the grand total of licensed population is 33,428. 496. So that's our current licensed population. On the next page is the written statistics for our California Law and Ethics exam for the RDH and RDHAPs. This is our status. Our last board meeting, they asked the staff to show how many candidates were taking their law and ethics, how many attempts they're taking on to pass the exam, and then they wanted to know how many were out of state that were taking the law and ethics exam. And so that's the additional information I provided for our written examination. So if you have any questions.
Yeah,
Okay.
Sorry, on the multiple attempts, one of the things that we wanted to know was how many multiple attempts? Is it one multiple attempt, or is it, when you look at that 124, is that the same people taking the same exam over and over again? Or is this 124 people that took it once and had to take it a second time?
So it's, they had to take it a second time.
Okay.
Sometimes, some of them had they had to take it 3 times.
So what's our highest number of having to take it?
3.
So they can only take it 3 times, or?
There's no limitation on how many times they can take the exam, but based off of my report, the highest for a candidate to retake the exam has been 3 times that they've tried to take it.
Are there any other questions or comments for Tracy?
I just have a little bit of concern still looking at the multiple attempts and people coming out of state. You know, when we look down at those bottom statistics, the 10 in that time period that took it out of state didn't have to make multiple attempts. And yet we've got people within our own state that were, it's concerning. I want to, you know, I feel like, especially as we talked about things yesterday, I think that we need to be open on telling people what it is contained in this test so that they know what to study for, and that we need to get the message out, especially when we look at the RDHAPs who have been practicing as an RDH. We want to make sure, when you look at 20 people as opposed to multiple attempts 9, that's concerning. That means that people that are out there practicing as an RDH and then are getting educated to become an RDHAP don't have the information they need in order to keep the consumer safe.
Okay.
I just want to piggyback on that, and I have communicated with the educational programs as well, and this is just my direct experience that I've shared with the board in the past as well. When I've been at outreach events with students, they don't take the law and ethics exam as serious as they do the clinical exam. They talk amongst themselves, and luckily I did have an individual who was licensed right in front of my booth with a separate group of students that were chatting about the law and ethics exam, because they were pointing at our table going, who are these guys? They didn't know. And the licensee was right in front, and I heard him, he says, they're the ones who issue your license. And they go, oh, do we really need to study for this law and ethics exam? I don't think it's that serious. And he goes, you better study for it, because if you don't pass it, you're not going to get your license. And so I do send out the reminders. It is, you know, we do have to take some responsibility and let the students take the responsibility to study for this. You know, we can provide some study materials, but, you know, we obviously can't give them the answers, but they do need to take responsibility to study.
And I agree with you on that. The part that I'm having a hard time with is looking at the RDHAP who is out practicing as an RDH in order to get an RDHAP license. 33% of those people do not know California law and ethics. They failed it. So there's something missing in this process.
So what is your prescribed solution?
Well, there's 2 things. I think that we need to be more definitive about what we say is going to be on the test so that they know what to study and what areas to study, because they're not going to memorize that whole book. I think that we need to, and then I think that we need to do a campaign to get the schools involved and give the schools more information on what we're expecting them to know. The vocabulary, the topics, I think, need to be covered.
Well, I would like I do agree with Tony, only because from teaching now for a while, and it's been a while since I took the test myself, but they did put the fear in us to study, and we did study the book. So, I don't know. Study the book. I don't know.
Yeah, there are other states that actually do open book on that, just to let you know. But
What did you say? I'm sorry. I
there are
didn't
other
hear you.
states that let you do open book on that.
Open book?
They give you the questions and you turn them in, but just.
Well, isn't that that's part of what our population should be able to do? If they have a question about something, they should be able to go to the book and look it up. And I don't have a problem with that at all. I think that's a good point, Tim.
That is a great idea. Is it timed? I'm assuming you have so much time for the test at that point.
Well, for my short stint in Maine, they actually just mailed you the questions and you turn them back in. So you didn't sit in a room, you just turned it back with your application. I'm not saying that's the best way to do it, but that's how another state did it, so.
My concern about that is that once you, if you're not going to be studying for it and you know that you can look at every resource there is, and then you've got a patient in front of you, and you have a situation where you have to be done in a certain amount of time because that's what's billable, and you don't have time to look it up. So you ought to be able to know it, and that means studying for it and learning it. And I went through my entire education, had a 3.91 grade point average, and I know nothing because I just studied for the test a whole lot. So my argument is really not that strong because you could pass the test and still not know it. But I think that if you have a open book, it's even worse. So. But I will also add that it's good because you can know where to go. So maybe that's what, I don't know what the schools are doing right now, but that might be a good way to prepare people, is to come up with the hardest questions they can think of and have them look them up.
Or even know that the book is there for them, I mean, getting familiar, so it's not so intimidating.
Right.
I think that's important that that in their context, it's not just practical, clinical things, but there's something behind it.
Well, it's because for the RDH, the students are taking the exam, it seems like the majority of them are passing, but for the RDH AP, almost half. But do we know, are they preparing, taking CE classes before they take the test? Do we know what preparation, are they asking for help, study materials?
I know in the RDH AP program that I went through, it was a big focus. But once I went into that test, the focus that we had in the classroom didn't match what the test had in it. And that's why I'm saying, to be able to say, make sure you look at this, make sure you look at that. You know, I think being more open about something like that, instead of being, the questions need to be developed and to be private, but the content of what we need to be studying, I think, needs to be clearly defined.
I would like to say that as a board member in looking at this particular report, it appears that RDH candidates fairly consistent in the 80% low 80s passing. I did key in on the obvious recent concern, because if you look at the RDH AP pass rate, it was in the 80s, the upper 80s, until this latest grouping. And so my question then is, do we know, Tony, has anything changed with regard to the exam itself? Has there been a change in the exam? That's the first thing I thought of when I looked at that, is maybe something has happened in the change. The other thing that I wanted to mention is in the current candidate's guide for these exams, the law is cited. It does tell them specifically what laws to look at. Mm-hmm. So we do have that currently. So that's why I think maybe something happened with this particular round of exams. And that might be something you'll just need to ask about. I think it's worthy of us as a board to say, hey, we noticed a big drop here in the APs. I mean, 20% is a big drop. And I think I would ask that you might question and find out if something unusual happened, or maybe they reconfigured the exam in some way that that caused it to be that way?
I think in that time span, there was a new exam because I did review one at the beginning of summer, but I will research and check into that to see what occurred, and then hopefully find out some answers to see if there was a drastic change.
And then we'll have that reported to us at the April meeting?
Correct.
And I think that all of this information, especially with the OEPS report and them changing our law and ethics exam, I think that we really need to, the next time that that's brought back to us, have this as part of our discussion so that we can get some of the more detailed information as to how they are going to implement our new exam.
Any other comments from members of the board?
I just had a comment back on the licensing statistics because this issue had been brought up before. As far as the delinquent licenses are concerned, I know the number is high, but between the Breeze system sending out delinquency notices and us addressing individual licensees as they contact the board, we try to get notification to them on these delinquent licenses. And honestly, it's up to the licensee to act on it. So I just wanted to let the board know and be aware that we are working on it.
Is there a maximum number of times or years that we contact a delinquent or delinquent licensee?
A license can remain in a delinquent status for 60 months or 5 years.
Okay.
After that, if it's not renewed, it's automatically canceled
So
permanently.
we keep reminding them during that 5-year period?
Correct.
I do want to add that recently, under my license is also my school's CE provider license. And so we sent in our required reports, and if you went into Breeze, you would see there was a period of time that it said delinquent. And I had turned it in on time, but sometimes it takes a little while
Lag
for
time.
processing.
Mhm.
And so I think the Breeze system automatically says delinquent, when in fact it could very well be processing. And that might be one of the reasons why, maybe I'm wrong, but, okay.
Just to clarify, when you mail in your payment for your renewals, it literally can take up to 6 to 8 weeks. So that's why we're really trying to get everyone to get online, because if you do it online, the credit card goes through then, and if there's any deficiencies, you'll be able to call and say, Tracy, I paid the renewal, but let me check and see what's holding up your license. I can clear it, and your license will update in like the next 3 to 4 seconds after we clear it. But if you continue to mail your renewals in, it's going to take 6 to 8 weeks because they're being processed from DCA's cashiering department.
And after our discussion yesterday about licensing and having access to a computer, I called my one friend who does not like computers and asked her how she had registered. She said she went to the public library, which has internet, and they walked her through the whole process. So there is a way to do this, no matter where.
And then my last question, Tracy, was just that it appeared as though you have an updated report because your totals were a little different than what I saw here, unless I was looking at the wrong place.
Well, yes, what happened was I actually was looking at the document, and I noticed that I didn't have my subtotals. So I was reading the subtotals for you, and then for each section, I gave you the subtotals. And then the total population, the number is correct. I just wanted you to see that the active, inactive, and delinquent license subtotal was, for example, the RDHs was 23,434. You don't have anything in your report. So I just wanted to inform you I had omitted that part.
Any other comments from members of the board? Comments from members of the public, and you've patiently waited.
That's okay. Vicki Kimbrell. Yes, as a program director, educator, as well as giving the out-of-state SLN course, I, for one, purchased the DHBC the little booklet, the statute book, and give it to the students, and as well as the participants in the course. But I also take them to the website, to the PSI Candidates Handbook, and show them exactly the sections that are being used for the questions on the law and ethics exam, and show them the items that are used for the ethics part of the exam. So it's there, and my thought process was, are the questions on the exam then really mirroring or being reflective to what they're asked to study? Because if the questions aren't aligned with what they're being asked to study, then it could be that's part of the factor for the higher fail rate. So are the questions in line with what they're being asked to study? You know, you would think ethics or ethics or ethics or ethics, because the terms don't really change. But again, are the questions or the case scenarios, whatever's on the test, really in line with what they're asked to study? So as we go on in the future, should those tests change, that could be something to consider.
Or is it poorly worded? I mean, you have to do an analysis. Sometimes it could be either or.
Any other comments from members of the public? Seeing none. This again was an informational report, but we do have some follow-up that we wanted to have you come back with, so thank you very much. We will now go to, well, let me say that it is 10 after 12. We have several more items. We have one more statistical informational item, and then we have another item, and then we have the public comment for items not on the agenda. Do we want to keep going, or do we want to break for lunch? We could also do a short lunch break, that's right. Well, okay, let's just do a by hands. Who wants to keep going? Raise your hand. Okay, 1, 2, 3, 4. Who wants to have a lunch break, like a half hour? 1, 2. Okay, it looks like the let's go home right now win, so to speak. Okay, let's go on then. The report. Oh,
Madam President, does everybody checked out? No? What? Yeah, I am, but I just thought of that.
so if you. Why don't we then take a 15-minute break? We'll be back at 12:30 to give people an opportunity to check out. 15 minutes, 12:30.